Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Hey there, and welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorney, Sara Khosroabadi. With a focus on consumer protection, Sara offers helpful, caring, and professional legal services and advice. I am your host, Kevin Rosenquist, and today we're going to discuss what to do when collectors cross the line. You do have rights against harassment. Sara, it's so good to see you. Welcome back.
Good to see you too.
All right, so we're going to talk about some harassing collectors today, which I know you love to talk about. So let's get into it. When does a situation go from a lawful debt collection to illegal harassment?
Yeah, good question. So the Fair Debt Collection Practices Act is actually a federal statute that kind of gives you guidelines on what collectors can and can't do. So we've got two different kinds of collectors. We've got the third-party debt collectors like Midland, Portfolio, Calvary is one of them too. They purchase debt and then they collect on that debt for their own business. And then we've got companies like Bank of America, Wells Fargo, Chase that collect on their own debt, right? So there's a few different rules. The FDCPA, which is the Fair Debt Collection Practices Act, that kind of controls and tells the debt collectors like Midland, Portfolio, and Calvary what to do. Then in California, we have the Rosenthal Fair Debt Collection Practices Act, which helps us with any kind of debt collector. So even a landlord can be a debt collector under that, or the banks can be a debt collector under that. And a few key things that I've seen as far as like lawful debt collection versus harassment have been, for instance, harassment's calling you, 15 times a day, even when you've talked to them that day, or calling and leaving really awful voicemails saying that you need to pay the debt, leaving voicemails where they say you owe a debt. If it's anything more than this is me calling from so-and-so company, it can toe the line. And then I've also seen a lot of people get calls to their parents, to their family members. I've had a couple clients who have had a debt collector call. They found their information, I think on, our information's out there everywhere and it tells you who the relationships are, who's related to you. And they called like mom, dad, sister, cousin, and they just kept leaving voicemails and saying, we're trying to reach so-and-so, and wouldn't say why. So it kind of was like bordering, but at the same time, they were definitely harassing the client. I've also seen, people ask, don't call me at work. You're calling my work line. Please stop doing that. And then they refuse to do that as well. And then a couple of things that I've been dealing with lately are, especially if you have an attorney. So let's say you're going through a bankruptcy, which is when usually you have a lot of debt collection concerns or issues, right? Or you call an attorney like my firm and you're asking for help with regards to debt. If that attorney tells the debt collector, be it Bank of America or Midland, that you are represented, they can no longer contact you. And sometimes what they'll do is they'll contact you anyways instead of contacting your attorney. And that's also, that also leads to definitely harassment.
Yeah, that's something in all practices of law, right? Once you've hired the attorney, you got to talk to the attorney from now on. You can't be calling me.
Right.
Yeah. It seems like kind of crazy because they know that what they're doing is wrong, obviously. They know it's harassment. What are the punishments? Are the punishments not severe enough to where they care?
Well, yes and no. I mean, if you think about it, they're buying millions upon billions of dollars of debt, and they're buying it, especially, again, companies like Midland or Portfolio, they're buying it for pennies on the dollar. So there's a lot of money to be made in debt collection. And what ends up happening is, there's, like I said, the Fair Debt Collection Practices Act and the Rosenthal Act, it's supposed to stop them from doing that harassment or behaving that way. But in reality, there's so much more money to be gained in what they're doing. For every 10 people that they contact, maybe one or two of them actually files a lawsuit. And so maybe even less because people don't know their rights.
Right,
so for them, they're probably making way more money with these tactics rather than just letting it go and or trying to be as compliant with the law as possible. The other issue I see a lot is a couple of these companies are really big mills, right? Like they just have so many employees and it is a burn and churn. So revolving door of people who come in, they don't know anything about the law. They don't know anything about collection. They get on the phone, they try to collect this money and they do everything wrong, right? It doesn't matter what procedures you have in place if you're not reading them. then you're not going to be following the guidelines.
Mm-hmm. Yeah. You mentioned the calling parents and siblings and family members and all that stuff. Is that allowed?
No.
Yeah.
So it's allowed to get your address if necessary, but that's it. That's all they can really say is like, do you know where they're at? Do you have their address? But we oftentimes get people who say they told my dad or they told my mom that I owe money, which is towing that line. So if you're like, hey,
Yeah.
this is Midland, have your daughter call me back. She's not paying back her debt. Definitely something that is in violation of the Fair Debt Collection Practice.
And so in that situation, do they get, so they don't necessarily get punished unless somebody comes after them. Is that true?
Right. So
Okay.
it's like anything else, right? So
Yeah.
if you have if you, for instance, are getting harassed like that, you could contact an attorney who does consumer protection and files lawsuits under the Fair Debt Collection Practices Act. What then would happen is we would file a lawsuit, and then depending on what they did, what they, how much, how egregious it was, that's where we look and see what the damages are. So oftentimes these cases are all actually strict liability cases. That means that it doesn't matter how bad it was. If they did it, they did it. They're on the hook for it. And you can get up to $1,000 in statutory damages. And then also they have to pay your attorney's fees and costs if you prevail. So what ends up happening is we take a look at the case and go, okay, we have that strict liability. We know, for instance, they know that Midland knows that I represent the client, right? They still contact the client. So that right there, doesn't matter why they did it, is a lawsuit we can file. Then that stress that client goes through, that's what we can kind of look at the damages and determine, what the, how much of I hate to use the word punishment, but how much of a punishment would be, afforded to Midland. But again, I don't know if you've seen it out there. There's class action after class action after class action against these really big banks and against these really big companies, and $17 million or $20 million just seems like a drop in the bucket for them, and they keep going. So it doesn't seem to faze them too much, but it definitely has afforded different, changes in the law. So the good thing is we do have the Fair Debt Collection Practices Act and the Rosenthal equivalent, which is, California. If it's not a third-party debt collector, you can still sue in California. So we still have those, and those are definitely helpful. At least it's something that we can kind of fight back with.
Well, you said that 17 million is a drop in the bucket. 1,000 is definitely a drop in a bucket. So like 1,000 and some attorney fees. Yeah. There's no motivation for them to follow the law in that scenario.
Not really. But at least there's a sense of vindication for our clients. At least they're not dealing with harassment anymore. And it depends. Again, I had one client who had PTSD. He was a veteran, had PTSD, and the person was relentless, would not stop contacting him. He said, stop calling me. You're calling me at work. They refused to stop, and they kept kind of antagonizing him instead of just letting it go. And so we ended up filing a lawsuit. And, at the end of the day, a lot of our clients want an I'm sorry or an apology, which they're probably not going to get, but it doesn't hurt when you've got some money to kind of move on and create something else in your life.
Yeah, you felt like you got something out of it where that'll help. Yeah.
Exactly.
Yeah. So as far as the calling a job goes, obviously that's not allowed either, but that could really shed a poor light on you, like for your employer, especially if these people do what they do in those other situations where they tell them why they're calling. So what generally will happen in that scenario? Is it the same thing as if they called a family member, or is it different?
It's the same thing. So the Fair Debt Collection Practices Act and the Rosenthal Act, they kind of encompass, there's a nice long list of things that debt collectors can't do. And it kind of encompasses all of it. So like I mentioned, some of it, like for instance, if they send you a letter and that letter has inaccurate information on it, or it doesn't have all of the information necessary, then that might be like $1,000 case where you're looking at just statutory damages. But in an instance where they're calling family members and now you're embarrassed because now your family knows that you owe money, or they're calling your work and it's affecting your work, and or you get in trouble for having calls at work, that's when it gets pretty dicey as far as the practices that they're doing and what the debt collectors, how the harassment works. So it definitely can get pretty expensive for these companies when they take it that far.
Do you recommend people, as best as they can, document all the harassment, all the calls, all as best they can?
Yeah, absolutely. When we speak with clients, we ask all of those questions. We want to know, when did they call? When did you tell them to stop contacting you? Did you do it in writing? Because that's really great, especially if you have evidence, right? Like imagine in front of a judge or a jury, you're like, here's my letter where I
Hmm.
faxed to them. Here's my confirmation that they got my fax that says stop contacting me. And they still continued to contact me 10, 15, 20 more times. That definitely makes people upset, right? So it's like, that's the law. Stop contacting them. Don't harass them anymore. And these debt collectors are supposed to be educated and supposed to be trained in the Fair Debt Collection Practices Act and the California equivalent. So there's no excuse really as to them stepping outside the bounds and doing that stuff. Sometimes you get just a rogue person who, for some reason, I don't know, gets excited about harassing people, and it's not okay. And so yeah, we definitely say document everything, take pictures, screenshots of your phone when they do call in, save your voicemails, make sure that you at some point, stop answering the phone if you want to, because it gets too much. But I always say, pick up the phone and say, leave me alone, and hang up.
Hmm.
This can be as easy as that.
Yeah. Yeah. And I'm sure they're financially motivated, right? I'm sure they get something if they can close accounts. They get a bonus or they get a commission or whatever it is. So, you get that wrong person, that wrong personality, they'll do whatever they need to do.
I can't imagine that they don't. I can't say for certain that they do.
Yeah.
I can't imagine that there isn't some incentive, whether
Yeah.
that be a bonus or something. With some of these cases, I'm like, what was the motive behind, all of these calls, or what was the motive behind this behavior?
Yeah. Otherwise they just call and be like, oh, I can't do that. It's a 9 to 5. I'm getting paid either
Yeah,
way. So whatever,
yeah.
who cares?
Exactly, exactly, exactly. But I can't say for certain. I mean, I've never actually asked that question in a deposition, and I don't think that I would. But you never know what the motivation is behind this. But the problem is, again, when you have a revolving door of employees that are coming through, it's inevitable that they continue to harass and do this to consumers.
Well, yeah, it's not exactly the most desirable job in the world either. So, for most of us, that sounds like my nightmare, having to call
Yeah.
people to collect money. So, like, I mean, honestly, yeah, I mean, people probably don't last very long in the industry.
Mhm.
And then, like you said, they got to keep replacing people and they don't train them properly.
Yeah. It also, I think, for me at least, I would become jaded, right? If somebody kept saying like whole,
God, yeah.
crash happened and everyone really was filing for bankruptcy. So I think at some point they hear the story so often that even when I call them and say, hey, I'm negotiating on behalf of my client, they'll say, yeah, I've heard that before, or I'm really sorry your client's going through that, but unfortunately I have a job to do. So I think they get jaded, and I think that they hear the
Yeah.
same stories over and over again, and then they like lose all empathy, which is really sad too. So it can be definitely really hard dealing with debt collection agencies.
Yeah, I could definitely see how you could become jaded. Again, not a desirable job. You hear the same thing all the time. People get defensive. People don't pick up the phone. Yeah, I could see that being a case for sure. Not trying to defend them. I'm just saying.
No, I
But
know, I
yeah,
know.
I could see how that could
I get
eventually get to that point. Yeah. So if someone is feeling threatened or intimidated by a debt collector, if they feel harassed, what should they do?
Yeah. So usually with consumer protection attorneys, you're going to have either a free consultation or you're going to have an attorney. Usually with the FDCPA, it's a fee shifting statute. So I usually get paid by the other side when we win. I would say contact an attorney. Don't be afraid to contact an attorney because you think it might be too expensive or they don't have time to speak with you. Contact an attorney, see if your rights have been violated, and kind of go through and explain all that's happened to you. Again, sometimes I get clients who call me and they're so frustrated that they're like, I don't know any of the answers that you're asking me. I just know that I'm being harassed, which is okay. It just doesn't give me as clear of a picture. So I would say document everything that you can, get on the phone with the attorney as soon as possible so that you can get some relief from that harassment and stress. But also, I mean, things you can do in the interim is send out that cease and desist letter, say, stop contacting me on the phone, email them if they accept emails and say, like, leave me alone. I'm not paying this debt. It's not mine. Those are things that you can do without having to get an attorney involved. But if it gets to that point that you're speaking of, I would say just contact an attorney and see what they can do for you.
Yeah, I can understand too. Why by the time someone talks to you, they're like that they're at their wits' end. They're
They
so
are.
tired of it.
Yeah, and they've been dealing with it for months or sometimes
Right.
even years. And it's a difficult situation, especially when you're dealing with a lot of debt. It's easy to put your head in the sand and just not answer your phone, but the stress of that is enormous in and of itself. So I say just reach out, figure out what your rights are. Sometimes we can help. Sometimes we can't. If there's no, if there's no harassment there, I typically like to tell my clients, look, if there isn't a violation, let's try to see if we can get this resolved. If we can't get it resolved because you can't afford it, what about bankruptcy as an option? So I think when you speak with an attorney, they'll go through all the steps, and then at least you have an idea of what you can do or what you want to do with the debt, and kind of give yourself some of that relief too from the stress.
Yeah, that's true too. Cause then you can get some real advice from someone who knows what they're talking about. You're not Googling, you're not asking ChatGPT, you're not talking to your buddy at the bar. You're talking to somebody who knows the industry, knows your options, and maybe can make it so it feels like you have legitimate options. Like bankruptcy, no. Is it ideal? No, not at all.
Right.
But sometimes it's the only thing you can do, and it can at least like give you some peace of mind.
Right. And a lot of people have misconceptions about bankruptcy. So I
Sure.
go through that too. I don't practice bankruptcy myself, but I will at least give you some information as to what that's going to look like, how it'll impact you, and then get you to a bankruptcy attorney that I trust out here in San Diego or in Southern California too.
Yeah, I think all of our generation, all of our parents scared the bejesus out of us when it comes to bankruptcy. It's like,
Absolutely.
you'll never get a car again. Like there's so many big, big scary things that people talk about. I think you're right. There are a lot of misconceptions.
Yeah.
All right. Well, thank you for joining us on Navigating Consumer and Family Law Challenges, insights from SoCal trusted attorney Sara Khosroabadi. To connect with Sara and her firm, you can visit k&hlawgroup.com. And don't forget to subscribe to our channel. We like having you here. Got lots more stuff coming your way. Sara, so great having you here. Thanks for all the insight. Appreciate your time.
Thank you. I appreciate you too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.